This property is now under HOA control for unpaid assessments totaling $47,000. You have 24 hours to vacate before we change the locks and dispose of your belongings. That's what Kenneth Bradshaw screamed at me while waving a fraudulent court order. His pink dress shirt stretched tight across his bloated gut, black dress pants riding up as he gestured wildly with his clipboard. The smell of his cheap aftershave mixed with morning coffee and pine needles as he stood there on the deck of my grandfather's lake cabin, absolutely convinced he'd just stolen $340,000 worth of prime Colorado waterfront property through some bureaucratic loophole. I'm Judge William Harrison, and for 32 years I've served on the federal bench, including authoring the landmark Harrison Property Rights Protection Act that Kenneth was about to learn the hard way. But sitting there in my red and black checkered flannel shirt, watching this suburban dictator claim ownership of land that's been in my family since 1887, I felt the calm satisfaction of knowing exactly how this would end. What Kenneth didn't know was that in exactly 14 months, he'd be standing in my federal courtroom wearing orange prison scrubs, facing racketeering charges, property fraud convictions, and a civil judgment that would bankrupt 4 generations of his family. And I'd be the one wielding the gavel that sent him to federal prison for 23 years. But right then, with the Colorado Lake sparkling behind him and my coffee growing cold on the cabin's hand-hewn table, I let him rant about his fake authority. Because I knew something Kenneth Bradshaw would never see coming. What would you do if some HOA tyrant tried to steal your family's century-old property through fabricated liens? Where are you watching from? Drop a comment and tell me your state. Because this story will show you exactly how to destroy property thieves using federal racketeering law and 3 decades of judicial experience. My name is William Harrison, and 18 months ago I thought inheriting my grandfather's lake cabin would provide the perfect retreat from the pressures of federal court. After 3 decades on the bench, handling everything from organized crime cases to constitutional challenges, I was looking forward to quiet mornings on Flathead Lake, reading legal briefs while watching Osprey dive for trout, and honoring the memory of Judge Samuel Harrison, who'd built this cabin with his own hands in 1923. Grandpa Sam had been a territorial judge back when Montana was still wild country, and he'd chosen this particular cove because it offered both stunning views and complete privacy. The cabin sat on 12 acres of pristine lakefront, surrounded by old-growth pines and connected to the main road by a winding gravel drive that discouraged casual visitors. The property had remained in our family for over a century, passed down through 4 generations of judges, lawyers, and public servants who understood that some things matter more than money. My father, Judge Robert Harrison, had modernized the cabin in the 1960s, adding electricity and indoor plumbing while preserving its rustic character. When he passed in 2019, the cabin came to me along with a manila envelope containing every deed, survey, tax receipt, and legal document dating back to the original homestead claim. Grandpa Sam's handwritten note tucked inside the envelope was characteristically direct. "Billy, this land has seen a lot of history. Don't let the bastards take it." For the first year after inheriting the property, I spent every weekend and vacation at the cabin, slowly working through decades of deferred maintenance while rediscovering the peace that comes from physical labor. There's something therapeutic about splitting firewood and patching roof shingles after spending weeks listening to attorneys argue constitutional law. The cabin became my sanctuary, a place where Judge Harrison could simply be Bill, where the weight of federal decisions could be set aside in favor of simple tasks like maintaining the dock and clearing hiking trails. The trouble started when Pine Ridge Estates development appeared on the adjacent property in early 2022. What had been pristine forest suddenly swarmed with bulldozers, survey crews, and construction workers building luxury vacation homes for wealthy out-of-state buyers. The developer, Bradshaw Properties LLC, had purchased 400 acres of former ranch land and was transforming it into an exclusive gated community with its own HOA, golf course, and marina facilities. Kenneth Bradshaw, the company's president and self-appointed HOA dictator, was a 50-year-old real estate speculator who'd made his fortune buying distressed properties and flipping them to wealthy clients seeking Montana wilderness experiences without actual wilderness inconveniences. At 58, Kenneth had the soft appearance of someone who'd spent decades behind a desk making money off other people's labor. His pink dress shirt and black dress pants becoming his daily uniform as he patrolled the development in his white HOA golf cart. At first, the development seemed like it might be a reasonable neighbor. The architectural guidelines emphasized rustic luxury that complemented the natural environment, and the initial residents were retired professionals who appreciated privacy and environmental stewardship. I attended the first few HOA meetings as a courtesy, introducing myself simply as Bill Harrison, a federal employee who owned the adjacent cabin property. Kenneth seemed pleasant enough during those early interactions, though I noticed his tendency to dominate conversations and his assumption that his business success qualified him as an expert on all subjects. The relationship began souring when Kenneth discovered that my property wasn't part of his HOA jurisdiction. During a casual conversation about lake access rights, he'd suggested that I might want to consider joining Pine Ridge Estates for the benefits of professional property management and community amenities. When I politely declined, explaining that my family had been managing the property successfully for over a century, Kenneth's demeanor shifted noticeably. His friendly smile became forced, and he began asking pointed questions about my property boundaries, tax assessments, and legal status. The harassment started subtly with Kenneth's morning patrol routine in his white HOA golf cart. He'd drive slowly past my property line, stopping to take photographs of my cabin, dock, and vehicles. When I asked about his interest in my property, Kenneth claimed he was conducting community security assessments and ensuring that neighboring properties maintained appropriate standards. His pink dress shirt and black dress pants became a daily uniform as he appointed himself the unofficial monitor of my activities, timing my arrivals and departures, documenting my guests, and maintaining detailed logs of what he called non-conforming activities on adjacent properties. The escalation accelerated when Kenneth began filing complaints with county officials about my property. He claimed my dock violated setback requirements, my septic system posed environmental hazards, and my gravel driveway created erosion problems affecting community property values. Each complaint required official investigation, forcing me to take time away from federal court duties to meet with inspectors, provide documentation, and defend property rights that had been established decades before Kenneth was born. Kenneth's strategy became clear when he offered to purchase my property for what he called fair market value, considering the regulatory complications. His initial offer of $180,000 for property assessed at $340,000 revealed his true motivation. He wasn't interested in community standards or environmental protection. He wanted to acquire my lakefront acreage to expand his development project. When I declined his lowball offer, Kenneth's harassment campaign intensified dramatically. The breaking point came during the Labor Day weekend, when Kenneth organized what he called a community safety inspection of my property. Without permission or legal authority, he led a group of HOA board members onto my land, photographing my cabin's exterior, measuring distances to property lines, and documenting what they claimed were code violations and environmental hazards. When I confronted them about trespassing, Kenneth claimed they were exercising community oversight responsibilities and protecting property values from neglected adjacent properties. That evening, as I sat on my deck watching the sunset paint Flathead Lake in shades of gold and crimson, I realized that Kenneth had made a fundamental miscalculation. He'd assumed I was just another elderly property owner who could be intimidated through bureaucratic harassment and legal threats. What he didn't know was that I'd spent 3 decades on the federal bench specializing in property law, racketeering cases, and organized fraud. Kenneth's final mistake was underestimating his opponent. He thought he was bullying some retired federal employee who owned a rustic cabin. What he'd actually done was declare war on the federal judge who'd written the legal precedents he was about to face in court. The irony was delicious, and the justice would be swift, thorough, and absolutely devastating. Kenneth's first official assault came on a crisp October morning when I found him standing on my dock with his clipboard, pink dress shirt straining against his gut as he photographed my boat lift and measured distances to the shoreline. The smell of his cologne mixed with lake water and fallen leaves as he scribbled notes with the intensity of someone documenting war crimes. "Morning, Bill," he called out with fake friendliness, his voice echoing across the still water. "Just conducting the annual compliance review for waterfront structures. Your dock appears to be in violation of several county setback requirements." I was sipping coffee from my grandfather's favorite mug, watching this suburban dictator pretend he had authority over property that predated his entire development by 90 years. The violation notice he handed me was professionally printed on Pine Ridge Estates letterhead, complete with legal citations and a 48-hour deadline for compliance. The document was a masterpiece of bureaucratic intimidation, citing county codes, environmental regulations, and HOA covenants that supposedly applied to my property despite my never joining his association. Kenneth had done his homework, researching every possible angle to create the appearance of legitimate authority. The violations ranged from dock placement to septic system compliance to what he termed incompatible architectural elements that allegedly violated community standards. Each violation carried fines ranging from $500 to $2,000, with daily accumulation until compliance was achieved. The total potential penalties exceeded $15,000, obviously calculated to force either immediate compliance or property sale. The genius of Kenneth's strategy was its complexity. Most property owners would be overwhelmed by the legal language, confused by the multiple agency citations, and intimidated by the potential financial consequences. He'd created a bureaucratic maze designed to exhaust his target's resources and resolve. What Kenneth didn't realize was that he'd just handed detailed evidence of his fraud scheme to a federal judge who specialized in unraveling exactly these types of criminal enterprises. The harassment campaign expanded throughout October as Kenneth recruited other HOA board members to join his property surveillance operation. Gerald Whitman, a retired insurance executive, began photographing my vehicles and documenting their license plates. Marcus Thompson, Kenneth's business partner, conducted what he called environmental assessments of my shoreline, claiming to document violations that threatened community water quality. The coordinated nature of their activities revealed this wasn't random neighbor harassment, but an organized campaign to force property acquisition. My federal court experience had taught me to recognize conspiracy when I saw it, and Kenneth's operation displayed all the hallmarks of organized criminal activity. The participants had assigned roles, followed systematic procedures, and maintained detailed documentation of their activities. They'd established a command structure with Kenneth as the leader, created false justifications for their actions, and coordinated their harassment to maximize psychological pressure. The escalation continued when Kenneth began filing complaints with every government agency he could identify. The county health department received reports about my septic system allegedly contaminating lake water. The Environmental Protection Office got detailed complaints about erosion from my driveway threatening wetland areas. The building department was told my cabin violated current construction codes and posed safety hazards to neighboring properties. Each complaint triggered official investigations, forcing me to take time away from federal court duties to meet with inspectors and provide documentation proving Kenneth's allegations were false. The pattern became clear when I started tracking the complaints systematically. Kenneth filed reports every Tuesday and Friday, always with different agencies, always citing different violations, but always demanding immediate action to protect community safety and property values. The complaints were too detailed and too coordinated to be random harassment. They followed a strategic plan designed to overwhelm me with bureaucratic pressure while creating the appearance of legitimate regulatory concerns. Kenneth had essentially weaponized the government inspection process, turning public agencies into unwitting accomplices in his property acquisition scheme. The psychological warfare intensified when Kenneth began organizing community meetings to discuss the problem property adjacent to Pine Ridge Estates. These gatherings, held in his development's community center, featured PowerPoint presentations about declining property values, environmental hazards, and safety concerns allegedly caused by my non-conforming cabin and activities. Kenneth positioned himself as the community protector, fighting to preserve their investment against a neglectful neighbor who refused to maintain appropriate standards. The meetings were carefully orchestrated propaganda sessions designed to build resident support for aggressive action against my property. Kenneth's manipulation of his neighbors was masterful in its cynicism. He exploited their financial anxieties about property values, their environmental concerns about lake quality, and their social desires to maintain exclusive community standards. By framing my century-old cabin as a threat to their modern luxury lifestyle, Kenneth transformed ordinary residents into willing participants in his harassment campaign. They began filing their own complaints, adding their voices to demands for official action, and creating the appearance of widespread community concern about my property. The financial pressure escalated when Kenneth's HOA began assessing what they called adjacent property impact fees against my land. These fees, allegedly authorized by county ordinances and environmental regulations, were designed to compensate the community for property value losses and environmental remediation costs caused by my non-compliant activities. The assessments totaled $8,400 and came with legal threats about property liens and forced sales if payment wasn't received within 30 days. Kenneth had essentially created a protection racket, demanding payment to stop harassment while threatening escalation if his demands weren't met. The breaking point came when Kenneth filed a formal complaint with the county claiming my property was abandoned and should be subject to adverse possession by adjacent property owners. His evidence included photographs of what he claimed were deferred maintenance issues, documentation of my irregular occupancy patterns, and testimony from neighbors about the property's neglected condition. Kenneth was attempting to use adverse possession laws to literally steal my family's century-old property through legal technicalities and false documentation. The adverse possession filing revealed Kenneth's ultimate strategy. He'd been systematically building a case to claim legal ownership of my property through what appeared to be legitimate legal processes. The harassment, the complaints, the documentation, the community pressure, everything had been designed to create evidence supporting his claim that I'd abandoned the property and that his stewardship justified legal ownership transfer. What Kenneth didn't realize was that adverse possession requires actual occupation and improvement of the property, not just harassment of the legal owner. More importantly, adverse possession claims against federal judges tend to receive very careful scrutiny from courts that understand the difference between legitimate legal processes and criminal fraud schemes. Kenneth had just filed false documents with a county court, creating federal evidence of mail fraud, wire fraud, and conspiracy to commit property theft. The war was escalating exactly as Kenneth planned, but he'd made one critical error in his strategic calculations. He thought he was fighting some retired federal employee who could be intimidated through legal complexity and bureaucratic pressure. What he'd actually done was provide a federal judge with detailed documentation of a criminal conspiracy that violated multiple federal statutes. The Harrison family had been defending this property for over a century, and Kenneth was about to discover that some fights you can't win through intimidation and fraud. The moment Kenneth filed that fraudulent adverse possession claim, he crossed the line from harassment into federal criminal territory, and my 32 years on the bench kicked into full investigative mode. I spent the following weekend in my cabin study, surrounded by law books and case files, building what prosecutors would later call the most thorough property fraud investigation they'd ever seen. The smell of wood smoke from the fireplace mixed with the musty scent of old legal volumes, as I methodically documented every aspect of Kenneth's criminal enterprise. What Kenneth didn't know was that Judge William Harrison had written the federal statutes he was violating, including the landmark Harrison Property Rights Protection Act of 2018 that made exactly his type of scheme a federal felony with mandatory minimum sentences. My investigation began with the adverse possession filing itself, and the document was a masterpiece of criminal stupidity. Kenneth had claimed continuous occupation and improvement of my property for the required statutory period, but my security cameras, utility records, and tax payments proved he'd never set foot on my land except for his harassment visits. He'd fabricated evidence of property improvements, claiming to have maintained structures that were actually maintained by my caretaker service. Most damaging, he'd sworn under oath that the property was abandoned, when county records showed I'd been paying property taxes, maintaining utilities, and filing required permits throughout the entire period he claimed abandonment. The federal implications became clear when I traced Kenneth's financing sources for his harassment campaign. The Pine Ridge Estates HOA was funded through resident dues, but Kenneth had been diverting those funds to pay for private investigators, legal fees, and what he called community protection activities without board approval or resident knowledge. The financial records revealed systematic embezzlement of HOA funds to finance his personal property acquisition scheme. When HOA embezzlement crosses state lines or involves federal agencies, it triggers racketeering jurisdiction under the RICO Act, transforming neighborhood harassment into organized crime. My analysis of Kenneth's complaint pattern revealed something even more damaging than simple harassment. He'd been filing false reports with federal agencies, including the EPA, the Army Corps of Engineers, and the Forest Service, claiming my property violated federal environmental regulations. Each false federal report constituted mail fraud and wire fraud, both federal felonies carrying up to 20 years in prison. Kenneth had essentially been committing federal crimes weekly for over 6 months, creating a paper trail that prosecutors would later describe as the most well-documented criminal conspiracy in Montana history. The conspiracy extended beyond Kenneth to include other HOA board members who'd participated in the harassment campaign. Gerald Whitman's surveillance activities violated federal stalking statutes when he began following me to federal court and documenting my professional activities. Marcus Thompson's environmental assessments of my property included trespassing on federal land adjacent to my cabin, creating additional federal jurisdiction. Kenneth had managed to turn his entire HOA board into co-conspirators in a federal criminal enterprise. My investigation revealed the true scope of Kenneth's ambitions when I discovered his correspondence with out-of-state developers about expanding Pine Ridge Estates onto my property. He'd been marketing my lakefront acreage to potential buyers while simultaneously filing legal claims to acquire it through adverse possession. The emails showed Kenneth promising delivery of my property within 12 months, accepting deposits from prospective purchasers, and guaranteeing clear title through what he called regulatory acquisition processes. Kenneth wasn't just harassing me. He was running an advance fee fraud scheme using my property as collateral for deals he couldn't legally complete. The financial investigation uncovered systematic fraud that extended far beyond my property. Kenneth had been using similar harassment tactics against 3 other property owners in the area, filing false complaints, creating bureaucratic pressure, and making lowball purchase offers when his targets became exhausted by the harassment. The pattern was identical in each case. Identify valuable property owned by elderly or absent owners, initiate harassment campaigns, file false regulatory complaints, claim authority through HOA or environmental concerns, and pressure targets into selling below market value. Kenneth had essentially created a criminal business model based on property theft through bureaucratic intimidation. The money trail revealed Kenneth's operation was more sophisticated than typical neighborhood harassment. He'd established multiple LLCs to hide his activities, created false documentation to support his claims, and coordinated with corrupt county officials who were receiving payments for expedited complaint processing. The conspiracy included a county inspector who'd been filing. Kenneth's desperation reached criminal insanity when he decided to escalate from legal harassment to actual property seizure. And the morning he made that fatal mistake, federal agents were already in position to document every felony he committed. It was November 15th, a crisp Tuesday morning with frost covering the cabin's deck, when Kenneth arrived with a moving truck, 2 security guards, and what he claimed was a court order authorizing immediate property seizure for unpaid HOA assessments. The smell of diesel exhaust mixed with pine needles and his cheap cologne as he stood there in his pink dress shirt and black dress pants. Clipboard pressed against his chest like a shield, absolutely convinced he'd found the legal loophole that would let him steal my family's century-old property. What Kenneth didn't know was that FBI agents were recording everything from 3 different surveillance positions, and I was wearing a wire that was capturing every word of his confession to federal crimes. The fake court order was a masterpiece of criminal forgery, complete with official seals, judicial signatures, and legal citations that would have fooled most property owners into believing they'd lost their rights through legitimate legal processes. Kenneth had obviously invested significant money in creating convincing documentation, hiring what appeared to be legitimate security personnel, and coordinating what looked like official property seizure procedures. The psychological impact was designed to overwhelm resistance through apparent legal authority, creating the impression that fighting back would be futile and potentially criminal. My federal court experience had taught me to recognize fraudulent legal documents, and Kenneth's forgery was obvious to anyone familiar with actual court procedures. The case number didn't match county court formatting, the judge's signature was clearly traced from publicly available documents, and the legal citations referenced statutes that didn't exist in Montana law. Most damaging, the document claimed authority under federal regulations that specifically exempted properties like mine from HOA jurisdiction. Kenneth had essentially forged a federal court order while simultaneously proving he had no legal authority to seize my property. The security guards Kenneth had hired were legitimate professionals who'd been deceived about the nature of their assignment. They'd been told they were assisting with legal property seizure authorized by court order and had no idea they were participating in criminal activity. When I calmly explained that the court order was fraudulent and they were being used to commit federal crimes, both guards immediately backed away from Kenneth's operation. The federal wire I was wearing captured Kenneth's increasingly desperate attempts to maintain control of his failing scheme. "This is a legitimate court order," he insisted, his voice rising with panic as the security guards retreated. "I have full legal authority to seize this property for unpaid assessments and regulatory violations. If you interfere with official proceedings, you'll face additional charges for obstruction of justice." Every word was being recorded by federal agents, who would later testify that Kenneth had confessed to multiple federal crimes while attempting to steal property using forged legal documents. Kenneth's backup plan revealed the true scope of his criminal desperation when he produced what he claimed were federal environmental citations requiring immediate property evacuation. The documents, allegedly from the EPA and Army Corps of Engineers, ordered immediate cessation of all activities on my property due to environmental hazards and regulatory violations. Kenneth had forged federal agency documents, complete with official letterhead and agency seals, creating evidence of federal crimes that carried mandatory minimum sentences of 5 years in federal prison. The psychological warfare escalated when Kenneth began making threats that revealed his knowledge of my judicial position. "You think your federal connections will protect you," he said, pointing aggressively while his pink dress shirt stretched across his gut. "But environmental violations and property seizures are handled by regulatory agencies, not courts. Your judicial immunity doesn't extend to criminal violations of federal environmental law." Kenneth had just admitted he knew I was a federal judge while simultaneously threatening to use fraudulent federal documents to steal my property. The climax came when Kenneth ordered his remaining accomplice, Marcus Thompson, to begin removing my personal property from the cabin. Marcus, apparently unaware that federal agents were watching, began loading my grandfather's furniture onto the moving truck, while Kenneth supervised with his clipboard and measuring tape. The federal wire captured Kenneth's detailed instructions about which items to prioritize, where to store the stolen property, and how to document the seizure for his fraudulent legal records. The federal agents moved in when Kenneth began attempting to change the locks on my cabin, transforming his fraud scheme into actual breaking and entering. Special Agent Sarah Martinez approached Kenneth with her credentials displayed, her voice calm and professional as she explained that he was under federal surveillance for property fraud and was now being arrested for additional federal crimes committed in the presence of federal agents. The color drained from Kenneth's face as he realized his theatrical property seizure had been a federal sting operation designed to catch him committing crimes on camera. Kenneth's arrest was captured on multiple cameras as federal agents documented every aspect of his criminal operation. His pink dress shirt was soaked with sweat as Agent Martinez read him his rights while other agents photographed the forged documents, seized the stolen property, and arrested Marcus Thompson for participating in federal property theft. The federal investigation expanded dramatically when agents discovered Kenneth's storage unit, containing property stolen from other victims through identical fraud schemes. Furniture, artwork, personal belongings, and legal documents from at least 6 other properties were found in Kenneth's storage facilities, revealing that his harassment of me was part of a systematic criminal enterprise that had been operating for over 3 years. Kenneth hadn't just been harassing one federal judge. He'd been running a criminal organization that specialized in stealing property from elderly and vulnerable homeowners across multiple states. The money trail revealed Kenneth's operation had generated over $2.3 million in stolen property and fraudulent proceeds, all of which was subject to federal forfeiture under racketeering statutes. His Pine Ridge Estates development was built using proceeds from property theft. His personal assets were purchased with stolen money, and his entire lifestyle was funded by criminal activity. Kenneth's harassment campaign had triggered a federal investigation that would ultimately seize everything he owned and send him to federal prison for the rest of his life. The federal grand jury that had been investigating Kenneth's activities returned a superseding indictment with 47 federal charges, including racketeering, mail fraud, wire fraud, money laundering, conspiracy, civil rights violations, and interference with federal judicial proceedings. The indictment named Kenneth as the leader of a criminal organization that had operated across 6 western states, stolen property from over 30 victims, and generated millions in criminal proceeds through systematic fraud and intimidation. Kenneth's world was collapsing faster than his fake legal authority, and he had no idea that his next court appearance would be in front of the federal judge, whose property he'd tried to steal through forged documents and criminal conspiracy. The federal courthouse in Billings had never seen anything quite like United States v. Kenneth Bradshaw and Associates, and the irony wasn't lost on anyone that Kenneth would be facing sentencing from the very federal judge whose property he'd tried to steal through forged court orders and criminal conspiracy. The courtroom was packed with victims, federal agents, media representatives, and legal observers who'd come to witness what prosecutors called the most comprehensive property fraud prosecution in Montana federal court history. Kenneth sat at the defendant's table in his orange prison jumpsuit, his pink dress shirt and black dress pants replaced by federal detention clothing, looking like a deflated balloon as he faced the consequences of targeting the wrong federal judge with his criminal schemes. I'd recused myself from presiding over Kenneth's case due to obvious conflict of interest, but federal sentencing guidelines and victim impact procedures required my testimony about the scope of his criminal activities and their impact on federal judicial proceedings. Chief Judge Patricia Williams, my longtime colleague and friend, would be handling Kenneth's sentencing with the kind of judicial precision that makes federal sentences educational experiences for career criminals. The smell of furniture polish and legal tension filled the courtroom as Kenneth's attorney, an overworked public defender named James Morrison, prepared to argue for mercy in a case where mercy would be both inappropriate and insufficient. The evidence presentation took 3 days and filled the court record with overwhelming documentation of Kenneth's criminal enterprise. Federal prosecutors presented 847 pieces of evidence, including the wire recordings of Kenneth confessing to federal crimes, photographs of his forged federal documents, financial records showing $2.3 million in stolen property and criminal proceeds, and testimony from 32 victims who'd been targeted by Kenneth's harassment and theft schemes. The scope of his criminal organization was staggering, involving corrupt officials in 6 states, fraudulent title companies, and a sophisticated money laundering operation that had been stealing property from vulnerable homeowners for over 5 years. My victim impact testimony provided the court with detailed analysis of Kenneth's criminal methods and their broader implications for property rights and judicial independence. "Your Honor," I began, addressing Judge Williams while Kenneth squirmed in his seat, "the defendant didn't just attempt to steal my family's property through fraud and intimidation. He systematically undermined federal judicial proceedings by targeting a sitting federal judge with criminal harassment designed to interfere with official duties. His actions represent domestic terrorism disguised as property disputes, and his criminal organization poses ongoing threats to property rights and judicial independence throughout the western United States." The financial destruction was swift and comprehensive, as federal forfeiture proceedings seized every asset Kenneth had acquired through criminal activity. His Pine Ridge Estates development, valued at $4.7 million, was forfeited to compensate victims of his property theft schemes. His personal residence, luxury vehicles, boats, and investment accounts were liquidated to fund restitution payments to the 32 families he'd victimized through harassment and fraud. Kenneth's entire lifestyle, built on stolen property and criminal proceeds, was dismantled by federal agents who specialized in recovering assets from organized crime figures. Kenneth's co-conspirators faced their own federal justice as the criminal organization he'd built collapsed under federal prosecution. Gerald Whitman received 8 years for conspiracy and stalking, his insurance executive pension forfeited to pay victim restitution. Marcus Thompson, who'd participated in the attempted theft of my property, received 10 years for racketeering and federal property crimes. The corrupt county inspector who'd been filing false reports received 12 years for civil rights violations and conspiracy. Kenneth's criminal network was systematically destroyed by federal prosecutors who specialized in dismantling organized crime operations. The community impact extended far beyond Kenneth's immediate victims, as federal investigators uncovered systematic corruption in county government that had enabled his criminal activities. 3 county commissioners were indicted for accepting bribes to expedite Kenneth's fraudulent complaints against property owners. The county attorney's office faced federal oversight after evidence revealed selective prosecution of Kenneth's victims while ignoring complaints against his criminal activities. The title company that had provided Kenneth with confidential property information lost its federal licensing and faced millions in civil liability for enabling property theft through breach of fiduciary duty. Judge Williams's sentencing remarks became legendary in federal court circles for their comprehensive destruction of Kenneth's character and criminal enterprise. "Mr. Bradshaw," she said, looking directly at Kenneth as he sat trembling in his orange jumpsuit, "you have systematically victimized elderly and vulnerable homeowners through a criminal organization that specialized in property theft disguised as regulatory compliance. Your harassment of a federal judge represents an attack on judicial independence that threatens the foundation of our legal system." The sentence was devastating and final: 23 years in federal prison without possibility of parole, followed by 10 years of supervised probation with restrictions on property ownership, real estate activities, and association with HOA governance. Kenneth would be 73 years old before his release, and federal probation conditions would prevent him from ever again engaging in property development or community association activities. The civil judgment was equally comprehensive as federal court awarded $3.7 million in damages for civil rights violations, property interference, and intentional infliction of emotional distress. The judgment included punitive damages designed to deter similar criminal activities and compensate victims for years of harassment, legal fees, and property damage caused by Kenneth's criminal organization. Kenneth's bankruptcy filing was rejected by federal court due to criminal fraud, ensuring that civil judgments would follow him for the rest of his life. The legislative impact of Kenneth's case extended far beyond individual justice, as Congress passed the Federal Property Rights Protection Act, strengthening penalties for systematic harassment of property owners and creating federal jurisdiction for organized property theft schemes. The Harrison Amendment, named in recognition of my family's century-long battle to protect our property, established federal oversight of HOA governance and created criminal penalties for abuse of community association authority. My cabin on Flathead Lake became a symbol of successful resistance to property theft and criminal harassment, and I established the Harrison Property Rights Foundation to provide legal assistance to elderly and vulnerable homeowners facing systematic harassment from HOA tyrants and property developers. The foundation has helped over 200 families fight back against criminal property schemes, using Kenneth's case as a blueprint for federal prosecution of organized property theft. The annual Property Rights Day celebration at the cabin draws families from across Montana who have successfully defended their properties against criminal harassment and theft. Children play on the dock where Kenneth once stood with his fake eviction notices, their laughter echoing across water that reflects the mountains my grandfather loved when he built this cabin in 1923. Kenneth's story became a cautionary tale taught in federal law enforcement training programs about the dangers of underestimating your target when engaging in criminal activities. His harassment of one federal judge triggered the largest property fraud investigation in federal court history, destroyed a criminal organization operating across 6